Hello everyone, welcome to the live course of the Ekcel Academy. So today we will be starting, basically like the course on the new subject that is in the professional program, the resolution of corporate disputes, non-compliances and remedies. Please note this is a very important subject which is being very well thought of, and then they have introduced in the curriculum of the Institute of Company Secretaries of India. We being company secretaries, it is really important for us to know some of the important aspects of corporate disputes. Please note, if I have to talk about in the practice areas of a company secretary, it is really important that a company secretary should necessarily know that what all are the areas of practice he has, not necessarily for a practicing company secretary, even for a whole-time company secretary, what are the opportunities this particular course throws up. If you look at for any legal practitioner, if I have to talk about any legal practitioner for that matter, it is really important to know that there are three important streams. Okay, the three important streams which I have to talk about when it comes to the legal practices, one is related to compliances, the second one is relating to advisory, and the third one is relating to litigation. Okay, I want to name it this way. That is compliances and advisory, as well as the third important thing is litigation. So I need not talk about compliances. If I have to talk about compliances, you know very well that we are called as compliance professionals, or we are compliance officers, company secretaries, where the lot of legal challenges that we face. In the sense like, take for example, Companies Act of 2013 throws up a lot of compliance requirements, wherein a company right from starting, in the sense like, if a company wants to get incorporated, the moment it is incorporated, to survive as an active company, in the sense like if the Ministry of Corporate Affairs master data, if it has to show that your company is active, it is really important to ensure that there are a lot of compliance requirements which has to be looked into. So what are these compliance requirements? You know very well that meetings, or it might be forms filing and all that. So this is briefly what I'm talking about, the compliance perspective, or the areas which is available for the practicing professionals when it comes to the area of practice. That is the topmost priority, if I have to say, when it comes to a company secretary in his career. Advisory is part of compliance. Please note, like here, there are so many circumstances where a lot of corporate actions has to be taken based on the advice which is being given by the legal team. Basically, like even company secretary will advise on the corporate law matters, and now majority of the company secretaries have done the the law course also. Since company secretary will be holding the entire legal team. Why I'm talking about the entire legal team? Because now the requirement which is being enumerated in Companies Act 2013 is also same. So what is that requirement? Where the company secretary should be aware of, in the sense like he should be responsible for preparation of the report to the board of directors on the status of compliance of all applicable laws. So our role is not limited only to corporate law, it is extended to all applicable laws. That is what I mean to say. So if we focus on all applicable laws, definitely we can take the control of the entire legal as well as corporate secretarial compliances in our hand, and the corporate transactions will be advised by the company secretary's team or the legal team, whatever it might be, which will be there in the company. This is what it is. So advisory and compliances will sometimes go hand in hand, where there is a requirement that a company secretary has to necessarily advise a particular transaction, whether it will fit in the respective legal framework or not. The respective legal framework, what I'm talking about here is, there might be some transactions that the board of directors might have already decided, but to structure it in such a way that it fits in within the compliance requirements, that plays a very important role. Here the role of legal professionals will come in. So take for example, it might be the board of directors might have decided that they will be interested to take loan from all the interested, in the sense like directors as well as relatives, in the sense like private funding they are looking for. They are not going for public issue. The board of directors, because always they will be looking at the strategic manner, because they are responsible for funding the affairs, in the sense like if proper funding is not there, definitely it is difficult to run the business. So under those circumstances, if it is being coming to the legal department, that means the legal and secretarial department put together, they will advise whether loan can be taken from following people. If loan has to be taken, whether we have to issue debentures to them, or normal unsecured loan can be taken, or we should keep an option to convert that loan into equity, whether it will be treated as deposits or not. Like that, there are a lot of advisory things. Now coming to even CSR also, because board of directors would have decided to do the CSR activity on a specific area. Whether it will be considered as CSR for the purpose of Companies Act 2013 or not, the analysis is required to be done by the legal team. So this is about the advisory thing. Sometimes you may even have to draw up an opinion, or it might be a suggestion letter, whatever it might be, even that has to be given to the board members based on the legal requirements, in the sense like based on the report which is being given by the company secretary, basically like there will be, the decisions will be taken by the members of the board. Coming to the third important area of practice, or the scope which is available for any legal professional for that matter, please try to understand one of the important thing is, it is litigation. Majority of the company secretaries, whoever I have seen, they do not focus on the litigation related matter, because compliance and advisory role is very easy. The risk what you are going to take is very limited. Of course, certification related risk will be there. For that you will take the management representation, all that is fine. But there is nothing called you have to visit the court of law, appear on behalf of your client, follow up with the respective judiciary. All that role is not at all there. Please note, in the career of a company secretary, under Companies Act 2013 as well as the Insolvency and Bankruptcy Code of 2016, lot of opportunities are being thrown up. Okay, even take for example, when the company is facing investigation, when the company is facing inquiries from the respective departments, then also there will be a lot of active initiatives the company secretary, whether a whole-time company secretary or the practicing company secretary, has to take. So why I'm talking all this? Because litigation practice is one of the important growing area when it comes to the corporate professionals. That is really important. So this is the right time our institute has introduced this particular topic, the resolution of corporate disputes. Please try to understand that it doesn't happen in corporate world in such a way that everything will be very smooth. Please note, like what happens, what I have seen in my practice all these days. When take for example, like 2 or 3 friends who will be working in the same company, say it might be a huge software development company, they will be basically like there will be some sort of activities. So here, if I have to talk about, I will just answer your questions, friends. I will just finish this what I'm just talking. First, let me just finish on the litigation practice, and then I will answer the questions. Okay, so I will just do that. So here, the litigation area, what exactly? Litigation means what? That is also most important. Okay. Please note here, in corporate restructuring or something like that, we would have come across mergers, acquisitions and all, for which we all allowed to, in the sense like there is a requirement to go before the National Company Law Tribunal. But here also there is a requirement to go before the National Company Law Tribunal or appropriate legal authority. Please note, the most important thing is cause of action here. But whereas in case of mergers and amalgamations, cause of action is not necessary to approach the National Company Law Tribunal. Please note, National Company Law Tribunal being adjudicating authority under Insolvency and Bankruptcy Code, as well as for the mergers and acquisitions under Companies Act 2013, it is providing approval services. Please note, approval services I would put under compliance and advisory itself. I don't want to put under litigation. Correct? Because approval and advisory services also the judiciary will provide. That is National Company Law Tribunal. Because central government approval or something like that, whenever necessary, it is being delegated by the Ministry of Corporate Affairs to the National Company Law Tribunal, Regional Director, Registrar of Companies, like that it works. But here what I'm talking about in resolution of corporate disputes, that is really important that in the corporate world, the disputes are very common. I started with an example that, there are 2-3 people, who have basically, were working together, and then they were very good friends. They were into software development. And suddenly an idea came up, like, why do we have to work for this particular company? Since we are very well aware of software development, why can't we start our own enterprise? So those four people come together, and then, with all that, the new things like startup or something like that, which they have to do it, and they want to raise the funds or something like that, definitely like that Josh will be there when they want to start the business. They come forward and then they will incorporate the company. And now the challenge arises, like, when money is not there, or when more money, please note that dispute arises when there is no money, there is no dispute, correct? When lots of money flows in, if the venture is very prospective, generally this particular, the dispute arises. What kind of dispute? That, I should get more remuneration, and then how the remuneration has to be taken. I want to bring in my own relative on board, and the other fellow will not be happy. He will say, I will bring my own relative into the board. Like that, there are a lot of, the dispute which will come in, and, the deadlock, the management will face the deadlock. What kind of a deadlock? 4 directors will be there, 2 will become one party and other 2 will become another party. So they won't meet together. Minimum 3 directors required, to constitute the majority for the purpose of passing the resolutions or something like that. And deadlock will, the deadlock situation, because of the gap of communication, will kill the industry. I have seen many industries which is going to happen that way. So this is one area which we call, there will be some sort of oppression, there will be mismanagement. All these are important aspects which we need to discuss. First, let us try to understand what are corporate disputes and what are the means available for resolution of corporate disputes. And then there were a lot of inspection, inquiry and whatever, and what is the role which is required to be played. Okay, this is the litigation practice. Please note, all these days, this litigation practice was with the lawyer's domain, because National Company Law Tribunal is a quasi-judicial body, and only, prior to National Company Law Tribunal, the jurisdiction was with the respective high courts. Please note, if you have to visit High Court, or if you are allowed to appear before the High Court, you should be registered with Bar Council of India, and then you should be an advocate. So if this was not there, that is why the legacy, in the sense, like, only lawyers were going to the High Court and they were taking up the litigation related things. But now wonderful it is, before the National Company Law Tribunal, even practicing company secretaries can appear. So practicing company secretaries, if they are not lawyer, if they are not registered with the Bar Council of India as advocates also, since all corporate disputes are coming before the National Company Law Tribunal, definitely there is an opportunity available for practicing company secretaries to appear before the National Company Law Tribunal in all litigation related matters. Okay, because it is a quasi-judicial body. So hope, the question which is being asked by 2 or 3 people, like, compliances, advisory, litigation, role of CS in practice. Of course, basically, like, even if you take up, of course, if you take up the whole time company secretary, compliances and advisory will be his, the cup of tea. The litigation, of course, he will be assisting, but he will represent the company on his behalf, and he should go along with the practicing professional who is going to appear. But the role of CS in practice, yes, compliance, advisory and litigation, I agree. And to answer Padma's question, there is no necessity that he has to be a legal professional or a lawyer. Yes, even practicing company secretaries can appear before National Company Law Tribunal and take up litigation as their area of practice. That is very important. Okay, so with this introduction, I will just take you through the material. Let me share the study material. Okay. Yeah. Hope the screen is visible now. Yeah. So this particular paper, which we are talking about, the resolution of corporate disputes, non-compliances and remedies. So I will just give a brief on the syllabus, and then let me take you through some of the important concepts, because today only I am starting, so I will not hurry up. Let us try to understand the concepts. That is what always my focus will be. Today I will take you through briefly what is this subject is all about. Okay, and then I have made a series also, and then in the YouTube briefly on each chapter. I have spoken about what this particular chapter comprises of. Like that, it will be a short video of 5 to 10 minutes or even 15 minutes. Also, some videos. Please go through all that. I think a playlist is being already made. If not made, I will tell my team to make a playlist in the YouTube, so you will be able to go through that particular introduction to each chapter in the series of videos which I have made from this particular chapter. But now what I'm going to do is I will just introduce you, and then briefly I'm going to take you through this particular subject. Okay. So if you see this, it is not at all bulky. Okay, that is one feel I have to give you. Like corporate restructuring law and insolvency is little bulky, and other subjects are bulky. But here, this is not at all bulky. You have only very minimum. The syllabus is not very huge. The material is also sleek. Okay, the syllabus is for 100 marks, as you all aware. And let us see what is the expectation of the institute. If you see the syllabus here, and then the first important thing what I always talk about is what is the objective, why we need to study this particular paper, and what is the expectation of the institute. That is most important. Please see here, to acquire knowledge of various kinds of corporate disputes and non-compliances under various laws and their resolution and management. Please note here, we are not concentrating only on Companies Act 2013 non-compliances. See, they are focusing on various laws. Okay, straight away we went there. 1 minute. Okay, yeah. I will just come back to the syllabus. Yeah. Okay, so basically here it is to acquire of various corporate disputes. Please note here, the primary focus is on, the first important area is on corporate disputes. The second one is to how to address the non-compliances under various laws. Please note, all non-compliances are not irreparable. Irreparable means there is no possibility to correct it. Majority of the compliances which is being thrown up as an obligation on a corporate entity are certain important non-compliances which can be fixed. How the non-compliances can be fixed? By way of following the legal procedure which is being provided in the respective enactments. If you look at the provisions of Companies Act 2013, there are various options available. Okay, what are various options? Like you might go for compounding, you might pay the penalty, okay, and then you might basically compounding, correct? Compounding or compounding of the offenses are one of the important ways in which you can come out of the the grievances which is arising out of non-compliances. So to fix the non-compliances or to fix the gap of the non-compliances, there are various routes available. But when it comes to corporate disputes, how to resolve corporate disputes? What are the techniques available to resolve corporate disputes? All that we can necessarily look into. Okay. So here, if I have to talk about some of the important, aspects here, which is being specifically available for the transactions which is related to that. The first important content, the first important chapter which we have to discuss in detail will be the shareholders' democracy and the rights. Please note here, in case of the law relating to majority powers and minority protection and class action suits, why should we discuss this in detail? Majority of the corporate disputes will fall under operation and mismanagement. That is what the next important topic which we will discuss. Why I'm talking this? Because, so if you have to look at the specific terminology here, okay, the law relating to majority powers and minority protection. Please note here, I being a shareholder, what are the various laws in the sense like protection available? That is the objective here. Shareholders democracy. What is democracy? It is being defined by majority of the people, by the people, to the people, and for the people. Correct? Basically, like to the protection of the, basically the principle here is the interest of the shareholders are required to be protected. Democracy means the shareholders, because company is formed out of the funds which is being provided by the shareholders of the company. Shareholders delegates the authority to the board of directors. Correct? If you look at how the country is managed, who are, the citizens of the country own this particular country. That is how it looks like. It belongs to the citizen. But the entire citizen, 135 crores or whatever it might be, they cannot manage the affairs of the country. So what we have done, we have delegated to the representatives at various levels. It might be at village level, taluk level, district level, state level, as well as at the central level. We have delegated it. So here, since we have the authority to choose to whom that particular power has to go, the same way it works in case of company also. The shareholders will have, since they are the owners of the company and they have invested in the company, they have to delegate it to the board of directors of the company. What are the powers, law relating to majority powers? Take for example, being majority shareholders. Take for example, like you might have, you know very well, because you people have cleared your executive program. Whoever is listening to, whoever is attempting to write this particular paper, that is resolution of corporate disputes, which is very, very important, and you should be aware of it, that, we have the concept of ordinary resolution and special resolution. Please note, in case of ordinary resolution, 51% vote, in the sense like, when it comes to, take for example, there are 10 shareholders, 7 people attend the meeting. Okay. I will not look at what is the value of the shares they are holding. Out of 7 people, whoever is attending, majority of the people, like 4 people, if they say yes to the resolution is considered valid. But when it comes to special resolution, 51% in number representing 75% of the value. 51% in number representing 75% of the value of the share capital is what the requirement to pass the special resolution. That is where the role of majority will come into picture. What are the powers of the majority? Please note, there might be so many circumstances where, if you look at, in my example, I told you there are 10 shareholders. Out of 10 shareholders, there might be 8 shareholders who will be holding only some significant or minimum, say they are holding only 4% of the entire share capital, all these 8 people put together. Whereas remaining 2 people are holding 96% of the paid up share capital of the company. 96% of the paid up share capital means they are the majority shareholders in the company. The remaining 4% of the people is only for the namesake, or they are being given. Please note, if these 2 people attends the meeting and if they say yes, ordinary resolution as well as special resolution will definitely get passed. There is no necessity to seek the advice of remaining 8 people. Whether they attend the meeting or not, it is immaterial for the purpose of special resolutions. If these 2 people attend, if they say yes, they are holding more than 75% and majority powers are there. Take for example, there are some circumstances where this minority, please note, we need to understand what comprises of minority. Correct? Whether this 4% shareholder, of course, in colloquial language, if I have to say they are minority shareholders, when opportunity should be given for them to listen. Correct? Because these 2 people may not take the decision for the benefit of the company, let us presume, or they are involved themselves in the mismanagement, but still the resolutions are getting passed. Why? Because they are majority shareholders. Now that is where the law is looking at protecting the interest of the minority also. This is called minority protection. Very, very important. So in order to seek the minority protection, what are the conditions which are required to be satisfied? Okay, these are the important things. First chapter is really important to understand what are the powers of the majority shareholders, how the minority protection is required to be provided. So majority powers versus minority protection, this is what is the detailed discussion that we have to make when it comes to the chapter number 1. Please note here, there is one more important thing which is being introduced called class action suits. Under 1956 Act, please note, there was no recognition to other forms of investors. Like public deposits, all these people, they were not coming under the bracket of shareholders democracy and rights. If you are a shareholder, then you could have filed the petition as basically with respect to the petition with respect to operation as well as mismanagement was allowed. But if you look at the second important thing that is relating to the deposit holders and all, they never had the opportunity to go before the respective authority for the purpose of claiming their rights. So now the class action suits are being introduced, very famous. It is there in the Western world, which is being introduced in the Companies Act 2013 also, so that even the public deposit holders also will get the right to seek the remedies. Okay, so what are the protection available to the minority protection is available, as well as class action suits. These conceptual understanding we are going to study in this particular chapter. The next chapter is related to corporate disputes. Please note, the corporate disputes generally arises of operation and mismanagement. So we need to discuss this in detail. What constitutes operation? What constitutes mismanagement? With the assistance of lot of decided cases, because the facts and circumstances might be different. But we have to come to the conclusion whether it amounts to operation, whether a particular act amounts to mismanagement. If it is operation, what are the remedies available? If it is mismanagement, what are the remedies available? How many number of people can go ahead and file the petition? Please note here, it is really important that whenever operation and mismanagement is being identified, that is called as cause of action. So once the cause of action is identified, the next important activity, what it is going to happen is, we will go ahead and then we will file a petition before the National Company Law Tribunal. So while filing the petition before National Company Law Tribunal, it is really important to prove the cause of action. The petitioners has to prove the cause of action. So how they will prove? Then only the petition will get admitted in the National Company Law Tribunal. Otherwise, the petition won't get admitted. Please note here, we will be discussing about the both substantive provisions of law relating to coming to the conclusion whether it amounts to operation and mismanagement or not, and then the legal procedure which is required to be followed, what are the stages involved, and what are the remedies which we are going to get under operation and mismanagement, the law and practice. That is what is the detailed discussion which is going to happen in this particular chapter, that is corporate disputes. Then there are some circumstances like, even refusal of registration to transfer of securities, like few people won't, this is also one of the important, the litigation which may come up. Wrongful withholding of the property of company, a shareholder or a director, he will be holding the property as if it belongs to him, but it belongs to the company. So that is also like how to claim back if some property is being withheld wrongfully. Okay, that also has to be looked into. Corporate criminal liability, like, basically with respect to what are the, now we are talking about a lot of decriminalization related stuff, but still fraud and all, for which, there will be a lot of, that it will be treated as crime, and then for which there will be a criminal liability. So what amounts to criminal liability? What are the actions which will be taken by the wrongdoers? Okay, that is what we need to discuss in this particular chapter. So both civil trial as well as criminal trial we have to discuss. Okay, so that's what I will just leave it to you. Please go and then visit the playlist on this particular subject, that is resolution of corporate disputes, non-compliances and remedies. I think I have done around 10 videos on each chapter. It is a 10-minute video on an average, if I have to say, where each topic I would have discussed briefly, what this particular chapter comprises of. Okay, just do that. So frauds under Companies Act and IPC, because the third chapter is talking about frauds, because corporate frauds as well as fraud as per Indian Penal Code, because both the enactments has the jurisdiction. Please note, specific law prevail over general law. That is one of the important rule of interpretation, where Companies Act is also talking about fraud. So what are the identifications or what are the similarities is what we need to discuss in that particular chapter. The same way, misrepresentation and malpractices. Like, take for example, if there are any misrepresentation and malpractices, what are the basically the repercussions that we need to face? That is being provided as per Companies Act, RBI, SEBI, FEMA, Coffee Posa. Why Coffee Posa? Because there will be some sort of prevention of drugs, narcotic, NDPS Act also. And then there are other prevention of corruption related provisions, labor laws, money laundering, etc. under various laws, because here we are not restricting ourselves only to corporate laws. We are, basically like going beyond, corporate laws and discussing majority of the applicable laws. Regulatory actions. Okay, the next important chapter, that is chapter 5, which is talking about, there are various instances where we might face regulatory actions. What is regulatory action? It is very important that if any non-compliance is identified, okay, now the respective regulatory authority, desires of taking the action against us by way of sending a show cause notice or sending an arrest warrant if it is a criminal trial, inquiries, investigation, inspection, search, seizure, arrest. All these things would come under the regulatory action. Okay. So now please note here why bail is also mentioned, because in certain circumstances where if it is arising out of criminal liability is there, of course, in corporate laws, majority of the things are non-bailable offenses, bailable offenses. And now we are talking about decriminalization. So this criminal liability, that is arrest and bail, all that has becoming limited. But still, it is not completely out of corporate laws. It is still there for the serious offenses like fraud. There are various authorities which may take regulatory action. It might be ROC, RD, SFIO, stock exchanges, SEBI, RBI, Competition Commission of India, labor law authorities, income tax authorities, enforcement directorate if it is money laundering related, CBI, economic offences wing, that is CBI's economic offences wing. All these people can take action against us. And how? What is the procedure? What is the primary role the company secretary has to do when a regulatory action is required to be faced? This is what we need to discuss in this particular chapter. Next one, if the defaults, adjudication, prosecutions and penalties are being provided, take for example, show cause notice, and then they are asking us to pay penalty after the adjudication or prosecution is over, how much has to pay, whether there is a requirement to take the DOL, directors and officers liability insurance. Please note, we being company secretaries has to necessarily suggest this, because there is an insurance product available which is called directors and officers liability insurance. If you see the next chapter, fines, penalties and punishment under various laws, we should be aware. Please note, this particular book you cannot throw it once you pass this particular examination. If you keep it with you, everything will be available in one go. Of course, institute will release the amended material whenever you want to can download, but still, if you want to understand handy that what will be the fines, penalties and all, you can keep it as a reference here. So this fines, penalties and punishment under various laws also comes hand in hand with defaults, adjudication, prosecution and penalties. So how to handle this? How the penalty payments has to go? If punishments or prosecutions has to happen, then what is the procedure which is required to be followed? Because we need to educate the board members, because for this kind of non-compliances, this is what is the punishment. This is what the maximum penalty which can be levied. We can challenge it before the respective regulatory authority. If they levy more penalty, we can obviously challenge that as per the law, you are entitled to levy only this much penalty. From where did you draw the authority to levy this big penalty? Like that, always we will have the authority to question them. For that, we should be aware of what are the penalties. So these two chapters talks about all that. And we should be, this is very important, we should be aware of both civil as well as criminal trial procedure and process. Because we being company secretaries, we are not trained in the courts. Correct? Whether you take up litigation practice or not, this particular civil courts, what I'm talking about, the National Company Law Tribunal is a civil court for all purposes, even though it is a quasi-judicial body. The functioning of the National Company Law Tribunal is almost similar to how a civil court works. So we should be necessarily aware of how exactly the civil court functions. What is the procedure? What is the trial? Or what is the civil, the procedure, the trial procedure and process is very important. The same way, the special courts constituted under Companies Act 2013 or the special courts as per the Securities Exchange Board of India or any special court for that matter, even under Income Tax Act, they will be governed under the Code of Criminal Procedure. It is called CRPC. We should be aware whether we are going to appear before the special court or we are going to hire an advocate and he will attend the courts on our behalf. We should be necessarily aware of what are the next important stages, because for the respective stages, we should be prepared in advance that what and all documentary evidences we need to produce, what and all evidences we need to produce, what are the next actions which is required to be taken, because we will act as, the person who will be the communication channel between the board of directors and the respective legal consultant who is going to appear before the trial courts. Please note, we call trial courts, the criminal courts are called as trial courts, who will be practicing, basically advocates. It is in the advocates domain who will appear before the respective civil courts. Even though I am a person, basically, like if I have to say, I have done my LLB as well as LLM, and then I have a Bar Council of India registration, which I have kept it in voluntary suspension. I might take up litigation practice before National Company Law Tribunal. Of course, I have already done it, but I'm not interested to go to civil court. Like that, it becomes, that trial court, criminal procedure, all these things, I'm not interested, because it comes, like this is the area of super specialization. That is what I want to call. Why super specialization? You be thorough with compliances, advisory, litigation, arising out of civil practice or whatever corporate law. Like that, if you specialize yourself, that will be good. What I'm trying to tell is, what are the various opportunities available which you people can choose. If you are very happy with the litigation, basically with respect to criminal trial or something like that, definitely we need to take a advocate who is well versed with the criminal trial, and you will be negotiating with him and you will be assisting with him, and then you will be acting as the communication channel with the board of directors, and to ensure that the trial is being taken care smoothly. Okay, so that is where our role will come in when it comes to the criminal trial. But whether you take up criminal law practice or not, we should be aware of the trial procedure. That is the basic objective of chapter number 7. Chapter number 8. Chapter 9 is talking about the relief and remedies. What are the various reliefs available? I told you compounding. Compounding of offenses is fixing the gap of non-compliances. That is most important, because all non-compliances, majority of the non-compliances can be fixed. It doesn't mean that all the non-compliances cannot be fixed at all. Whether it is under Companies Act or it is under SEBI or FEMA, mediation, conciliation, settlement and proceedings is also very, very important. Please note, if it is not that, permanent Lok Adalats are set up now. What is Lok Adalat? It is permanent mediation centers, where opportunity will be given for the parties to settle their disputes out of court. How they want to settle the disputes out of court? By way of communication, negotiation. Okay, please note why the dispute arises: because of the communication gap. If the people start talking openly, definitely there are a lot of chances to arrive at solution for a particular dispute. So the bridging the gap of the communication is what the role which will be played by the mediation people. So company secretary can also act as mediator. Who stops you not to become an arbitrator? Who stops you not to become a conciliator? Okay, there are various opportunities available in the field of arbitration and conciliation. I have seen nowadays, you might have also come across that whenever investment is coming in, okay, that is private equity, venture capital, or whatever it might be, there are so many circumstances where I have seen they will enter into shareholders agreement. That is one important document. That means after my investment has come in, how the, basically like the system has to run, in the sense like how the management of the company has to happen. In that, the resolution of the disputes, one clause will be there, which will not have the court at all. They will say that any disputes between the shareholders has to be settled through arbitration. Arbitrator has to be decided by both the parties to the dispute. Like that, it will be very clearly mentioned in the agreement, where they don't want to go to the court. They want to settle the matter before arbitration, or they want to settle the matter themselves, out of court settlement. So various reliefs and remedies will be available. So this chapter is talking about all that. And the last chapter will talk about the crisis management, because a lot of crisis situations, please note, 2020 and 2021, the entire world is facing this pandemic. This is crisis. How to manage crisis? And is there any professional liability during the crisis management? D&O policy, which I talked about, that is directors and officers liability insurance, the risk and liability mitigation, how exactly we need to be prepared, under what circumstances we need to approach in the sense like, the board of directors, what sort of advice we have to give to the board members. These are some of the important things which will be discussed in the last chapter. Okay, this is the brief overview of what is there in this particular subject. It is very sleek, okay, not very tough, but still it is very important topic because it will give you a hang-on experience the moment you are thrown up into the corporate world to pick up whether it is practice or whether it is whole-time employment. If you are aware of all this, it is very easy to sail through. Okay, so in the remaining what is that, in 10 minutes time, I am going to take you through the first chapter briefly, one particular topic I am going to pick up, the introduction I am going to discuss, and then the remaining topic which we can I will take you through in the next class. Okay, because today, since it is an introduction class, I wanted to keep it only for an hour. Generally, my classes will be for 1.5 hours. We will discuss the concept in detail, and then we will get into the previous question paper once each chapter is completed, or 3-4 chapters together. That is what the pattern I will follow. So this is to give you people a brief idea about the syllabus of what exactly this particular subject, that is resolution of corporate disputes, is all about. Okay, so now in the remaining 15 minutes, what I'm going to do is, let us try to understand some basic terminology which is being provided in this particular lesson number 1, which is talking about shareholders democracy and corporate disputes. Okay, I don't want to directly jump into the topic. Let us try to discuss the basics first, and then we can get into the details, because I'm not even interested in getting into the the Foss versus Harbottle and all that case today. Let us try to understand what is this concept of shareholders democracy is all about, because this is very important to understand that why the interest of the shareholders are required to be protected. Shareholders are, very well that they are the owners of the company. And what are the rights I, being a shareholder, I should possess? What is the legislative intention? Whether the legislative intention is to protect the interest of shareholders or to protect the interest of the majority shareholders, we should analyze and see. And then in this particular chapter, we need to understand that what are the various types of corporate disputes which may come up, and even what are the objectives which are available. If you see that in case of transfer and transmission of securities, what and all disputes may come up. Personation, what are the punishments available? Okay, securities fraud, investor education awareness, who can file class action suit? Why? Please note, this is something like, I remember, it is like, we used to do like programs which is talking about the introduction to the securities market, or investor awareness programs. Okay, Institute of Company Secretaries of India was authorized by the Securities and Exchange Board of India to conduct the investor awareness clinics or investor awareness programs. For each program conducted, from the Investor Education and Protection Fund, the Institute of Company Secretaries of India used to get money. I was part of this particular team from the Mysore chapter of Company Secretaries of India, where we used to go conduct the investor awareness programs in various taluk levels. Also we have done, even small town like Nanjangud near Mysore. And then we have gone to Madikeri, that is Coorg, which is there near Mysore. Locally, I'm talking about, because I'm primarily from the state of Karnataka and completed my studies from the city of Mysore. So there is Mysore chapter of Institute of Company Secretaries of India, where we have conducted the investor awareness programs, where we used to talk about all this. If you invest in the securities market, you will be given the title shareholder. If you are a shareholder, what and all the rights you have? That is what we have to study now in this particular chapter, from basics to what are the procedural safeguards available, what are the legal protections available, like that, we need to understand. So let me just discuss today what is this shareholders democracy is all about. I'm not even discussing any legal concepts here. We are discussing only the the general concept of shareholders democracy itself. If you look at what is this democracy, okay, before even getting into shareholders democracy, let us try to understand what is this democracy is all about. If you see this learning objectives only they have given, democracy indicates that government is, okay, you remember, I remember this. What is democracy? I remember mugging up when I was in 7th or 8th standard. There used to be a paper called civics. I don't know whether now social studies or something like that. There used to be a paper. In that social studies we used to call. Later on, the name got changed to social science. In that, there will be 3 parts: history, civics, and geography. Okay, and in civics, which is basically like only constitution or political science related stuff used to be there. There, I remember even today that I mugged up 100 times. Democracy means of the people, by the people, for the people. Okay, so what does that mean? I never knew, when I was in school. But now we can identify, basically like now as we grow in the profession, as well as, as we grow by age, we will try to understand some of the important concepts clearly. When I read it long ago, I did not, understand the concepts, but now I will be able to articulate it in a beautiful way. So democracy, correct? Shareholders democracy, let us see later. Democracy is a government. It indicates that the government is of the people, by the people, or by people and for the people. Correct? It comprises of people. Correct? Because every nation belongs to its citizens. It is of the people. And the government is set up by the people, correct? By following the electoral system. We will have the elections at the village level, taluk level, Jilla Panchayat, and then you have at the district level, as well as you have at the state level and at the central level. The elected representatives will be there, and those people has to work for the benefit of the people. This is what is democracy is all about. Excuse me. So this reflects that all the rule made by the government would serve the maximum welfare of maximum people under the theory of Bentham's utilitarianism. You might remember that utilitarian economy. Utilitarian economy means it is for the benefit of everyone in the society. It should not benefit only a particular class. It should not benefit a particular creed. It should benefit the entire population. Whether it comprises of only human beings, not necessarily. It does not just comprises of human beings. Now, if you see a lot of verdicts of the Supreme Court where for the rivers, they are giving person status. If they give the status of a person to a river, you being a person, for you under constitution, fundamental rights are being guaranteed. If the state violates the fundamental right, you have every right to file a case against the government. A writ petition can be filed. The same way, if a person status is being given to a river, on behalf of the river, someone can file a petition because I am getting polluted, like that. This is the theory of inclusiveness. Even environment also has to be taken into consideration. That is called as Bentham's utilitarianism. Okay. So in this context, okay, that is what they're trying to say. If you see, democracy is this, that is what they have explained. But if you see, in the context of shareholders democracy, how you can define it is, means the rule of the shareholders, by the shareholders, and for the shareholders in the corporate enterprise. That's all. Okay, nothing. Okay, so this is what we have to think of. So here, rule of the people, by the people, for the people. That is what is the concept of democracy. But if you see it here, in the same context, if you see it in the case of company, the shareholders democracy means Rule of shareholders, by the shareholders, and for the shareholders in the corporate enterprise. How exactly this can be achieved? Who will make the rule? Please note, when the company is getting incorporated, we will prepare the articles of association that will be made by the shareholders, in the sense like the shareholders or the promoters. Okay. Rule of shareholders by the shareholders, because rule of the shareholders, rule by the shareholders is being articulated and prepared, and it is available in the articles of association as to how the management of the affairs of the company has to be conducted. What are the circumstances where you have to approach me? What are the circumstances where general delegation is being given it to you? Okay, this is the discussion happening between the shareholders and the board of directors, where the shareholders has delegated their authority to the board of directors. How the management of the affairs of the company has to be conducted. Okay, it is by the shareholders, the rule of the shareholders by the shareholders, the rule of the shareholders prepared by the shareholders, delegated to the board of directors for the benefit of the shareholders themselves, because if the company runs very well, who can gain monetarily? It is the shareholders themselves, because a lot of dividend can be declared and all that. So precisely it is, to which the shareholders belong to. So now, once the board of directors, for them it is being delegated, it doesn't mean that the shareholders have no authority to speak at all. Because we say democracy is getting hurt or something like that. If you see a lot of YouTube channels in which some videos are getting deleted, if some video is getting deleted, suddenly the question arises, where what is democracy we are talking about? We don't have any right to talk whatever we want. Correct? You might have seen in the news also. All these things are general discussions which is going to happen. The same way in the context of the shareholders also, it is precisely the shareholders should be given right to speak, congregate, that means form an association, and communicate with the co-shareholders and to learn about what is going on the company. This is what is important thing which has to be given to the shareholders. That is what is most important, which we are talking about. Okay. 1 minute. I'm just facing this issue. Okay. So precisely, I will repeat once again, what does shareholders democracy mean? Shareholders democracy necessarily mean the shareholders should be given an opportunity to speak, that is right to speak. Congregate means form an association, the shareholders, and communicate with co-shareholders and to learn about what is going on the company. This is what is all about shareholders democracy. Whether this is ensured, yes, definitely it is ensured. How it is ensured, that is what we need to discuss by looking into the provisions of Companies Act 2013. If shareholders are not given an opportunity to speak, what are the remedies available? That is what we have to discuss. Okay, this is all about shareholders democracy. Let us see this in detail also. They have given it. Again, I'm going to the concept of shareholders in the present day, all the details they have given, but I think I have discussed enough. Some of the business, yes, whatever I have elaborated, like what constitutes articles of association, what are the important activities which has to come up. When I take you through the detailed things, I will go through majority powers and minority rights, which is very, very important. But just try to understand what is this democracy versus shareholders democracy. Okay, I think if you read this 4 lines, this first paragraph, it is so crisp and clear, to define what is democracy and what amounts to shareholders democracy. That will be more than sufficient. This is what the brief introduction about shareholders democracy. I'm not going to load you people with stuff in the first day itself. So with this, I'm going to stop my class today. In the next class, we can discuss the topics in detail with respect to majority powers versus minority rights. What is the importance of articles of association? Generally, like while incorporating a company, we should not be in a really hurry to complete the articles of association. Articles of association is such an important document. It is the constitution for the company.
detailed analysis has to be done, and then we need to draft the articles of association. We need to protect the interest of the shareholders in the AOA also. Okay, because if specifically it is not provided in the act, if it is provided in the articles of association, because entrenchment provisions are allowed in case of a private limited company, AOA will prevail. AOA, if it is approved by the registrar of companies, the shareholders will be given a lot of opportunity, and then the objectives as well as the the business of the company has to be carried out according to the ones identified as per the provisions of articles of association. So articles of association is a very important document. Okay, in the next class I'm going to discuss that in detail. Okay, if you people have any questions on what I discussed now, you are free to ask right now. Otherwise we can conclude the session today. Either you can do a YouTube chat, anything is fine. Okay, thank you all.